It's that time of year again. School bells are ringing, children playing at recess, moving trucks pulling up to dorm rooms all across the country. My name is Kelly Leiden-Medak, the founder and principal attorney at Cascade West Investigations Law, and I would like to wish you all a wonderful back-to-school season. As students, teachers, and administrators return to campus this month, I would like to take a few moments to talk about some of the legal and investigative developments that occurred over the summer. The purpose of this presentation is to give a general overview only and is by no means an exhaustive list. However, it is an attempt to compile resources into one back-to-school toolkit and to provide brief spotlights on a few important developments nationally and within the Ninth Circuit. A few disclaimers. This presentation is for informational purposes only. It is not meant to constitute legal advice or opinions. However, if you have any questions, please do not hesitate to reach out to me at cascadewestlaw.com. Let's get started. This presentation will discuss two recent notices of proposed rulemaking from the EEOC and DOJ, EOC resources on AI and Title VII, recent Supreme Court and Ninth Circuit case law under Title VI and Title IX, Dear Colleague letters issued by the Departments of Education and Justice, as well as an OCR compliance review determination in Verde Unified School District, and a recent assessment of Title IX compliance in the California State University System. Last spring, the United States Department of Education issued two notices of proposed rulemaking regarding Title IX. The department received over 150,000 comments regarding the proposed athletics rule and over 240,000 comments regarding the proposed non-discrimination rule. As the department works towards issuing a final rule this fall, I would like to take a moment to note two other important notices of proposed rulemaking that were issued over the summer. On June 27th, 2023, the Pregnant Workers Fairness Act went into effect. This law requires that covered employers provide reasonable accommodations to a worker's known limitations regarding pregnancy, childbirth, or related conditions, unless the accommodation will cause the employer an undue hardship. For purposes of this law, a covered employer includes private and public sector employers with at least 15 employees, federal agencies, employment agencies, and labor organizations. The PWFA protects employees from retaliation. It prohibits covered employers from requiring an employee to accept an accommodation, denying employment opportunities based on an employee's need for an accommodation, and requiring an employee to take leave if another reasonable accommodation can be provided. I have attached a link to a recent training the EEOC conducted explaining the PWFA in more depth. The EEOC issued a notice of proposed rulemaking regarding regulations for the PWFA on August 11th, and comments are due by October the 10th. The Department of Justice also issued a notice of proposed rulemaking on August 4th, 2023, indicating that it intends to revise Title II of the Americans with Disabilities Act in order to establish specific accessibility requirements for state and local government websites. Both the DOJ and the Department of Education have engaged in significant enforcement efforts the past several years to ensure website accessibility. I have attached a link to OCR's Digital Access series, which is comprised of 20 videos discussing how people with disabilities use technology, applicable federal regulations, and identifying and remedying barriers to access. Comments on the Title II Notice of Proposed Rulemaking are due by October 3rd, 2023. In 2021, the EOC launched an agency-wide initiative to ensure that the use of software, including artificial intelligence, machine learning, and other emerging technologies that are used in hiring or employment decisions comply with civil rights law. The EOC convened a hearing on employment discrimination in AI in January 2023 and has compiled useful resources on its website, eoc.gov/AI. On May 18th, 2023, the EOC released a new technical assistance document regarding artificial intelligence and Title VII of the Civil Rights Act of 1964. The document assesses whether the procedures an employer uses to make employment decisions, such as hiring, promotion, and firing, have a disproportionately large negative effect based on race, color, religion, sex, or national origin. This is referred to as disparate impact or adverse impact under Title VII. This guidance makes clear that the 1978 Uniform Guidelines on Employee Selection Procedures apply to algorithmic decision making tools when they are used to make or inform decisions about hiring, promotion, or similar actions. If use of the algorithmic decision making tool has an adverse impact, use of the tool would violate Title VII unless the employer can show such use is job related and consistent with business necessity. If an employer administers a selection procedure, it may be responsible under Title VII if the procedure discriminates, even if the test was developed by an outside vendor. Additionally, an employer may be held responsible for the actions of their agents, such as software vendors, if the employer has given them authority to act on the employer's behalf. In August 2023, the EEOC filed a joint notice of settlement and proposed consent decree in EEOC versus iTutor Group. In this case, the EEOC alleged that a tutoring provider programmed its online application software to automatically reject female applicants over the age of 55 and male applicants over the age of 60, resulting in a failure to hire more than 200 qualified applicants age 55 and older in violation of the Age Discrimination in Employment Act. According to the proposed consent decree, iTutor agreed to pay $365,000 to the rejected applicants and take corrective actions, including adopting anti-discrimination policies and complaint procedures, as well as providing training to supervisory and management employees. Many are saying this is the first AI-based anti-discrimination settlement, and I think it is a good opportunity to remind employers of the Title VII legal obligations with respect to emerging technologies. As decisions become more automated, employers cannot forget their legal obligations to ensure that technology does not perpetuate discriminatory practices or have a disparate impact on protected classifications. Moving to notable cases, we start with the Supreme Court's decision in June that consideration of students' race in higher education admissions is unconstitutional. In Students for Fair Admissions, Inc., the court found Harvard and the University of North Carolina's admissions programs unlawfully considered individual students' race, and that the asserted interests in the educational benefits of diversity were not sufficiently measurable and could not be subjected to meaningful judicial review. The court stated that the admissions programs disadvantaged some racial groups and employed racial stereotypes by treating an applicant's race as saying something meaningful about the applicant's lived experiences. The court also held that the programs lacked a logical endpoint that would guide courts in determining whether the school's diversity goals had been achieved, and the use of race in admissions was no longer necessary. In the next slide, I will address guidance that was issued in response to this decision, but for now, we look to two recent decisions out of the Ninth Circuit with Title IX implications. On June 13th, the Ninth Circuit held that Title IX prohibits sexual harassment on the basis of perceived sexual orientation. The case, Gobrowski versus Arizona Board of Regents, involved a first-year student athlete at the University of Arizona who alleged that his teammates subjected him to frequent sexual and homophobic harassment because they perceived him as gay. The Ninth Circuit found Title IX should be construed consistently with the Supreme Court's reasoning in Bostick versus Clayton County, which held that sexual orientation discrimination violated Title VII. In addition, relying on the Supreme Court's reasoning in Price-Waterhouse versus Hopkins, which held an employer cannot discriminate against a person for failure to conform to a particular masculine or feminine stereotype, the Ninth Circuit held the alleged harassment was based on the stereotype that men could only be attracted to women. This, the court held, is impermissible under Title IX. On August 17th, The Ninth Circuit affirmed a preliminary injunction regarding the Idaho Fairness in Women's Sports Act. The act bars all transgender women and girls from participating in or trying out for public school women's sports teams at every age and level of competition. The Act also provides for a sex verification dispute process whereby any individual can dispute the sex of any woman or girl student athlete in Idaho and require her to undergo medical procedures to verify her sex. Men are not similarly subjected to the dispute process under the Act. The case, Hecox versus Little, was brought by a transgender woman who wished to try out for the Boise State University's women's track and cross country teams, as well as Jane Doe, a cisgender woman playing on high school varsity teams, who feared that her sex would be disputed under the Act due to her masculine presentation. The Ninth Circuit held that the plaintiffs were likely to succeed on the merits that the Idaho law violates the Equal Protection Clause. A heightened level of scrutiny applied because the Act categorically excludes transgender women from women's sports teams and subjects women athletes to invasive sex verification procedures, but not men. While this case involves an interpretation of the Equal Protection Clause, it is important to note that the Title IX notice of proposed rulemaking would also make it impermissible to categorically deny athletic opportunities to transgender athletes. Specifically, the proposed amendment to Section 106.41b states that if a recipient adopts or applies sex-related criteria that would limit or deny a student's eligibility to participate on a male or female athletic team consistent with their gender identity, those criteria must, for each sport, level of competition, and grade or education level, 1. Be substantially related to the achievement of an important educational objective, and 2. Minimize harms to students whose opportunity to participate on a male or female team consistent with their gender identity would be limited or denied. While we wait and see whether this language is adopted in the final rule, for those in Washington State, it should be noted that the WIAA's handbook for 2023/24 states all students have the opportunity to participate in WIAA athletics and/or activities in a manner that is consistent with their gender identity. Athletes will participate in programs consistent with their gender identity or the gender most consistently expressed. I'm certain that gender identity in athletics will continue to inspire much debate. Just a few days ago, the Alaska Board of Education voted to ban transgender athletes from girls' high school sports teams. I hope to provide additional updates once the Title IX regulations are finalized in the upcoming months. Following the Students for Fair Admissions decision, ending the consideration of race in higher education admissions, there have been and will likely continue to be questions regarding how school districts, colleges, and universities can promote diversity and inclusiveness on campus. This month, the Supreme Court was asked to decide Coalition for TJ versus Fairfax County School Board out of the Fourth Circuit regarding the use of high school admissions. There are new legal challenges to workplace DEI programs. For example, a lawsuit was recently filed against two international law firms alleging that fellowships designated for historically underrepresented individuals in the legal profession violates the Civil Rights Act. Complaints have also been filed alleging that legacy admissions in higher education violates Title VI. As these new challenges progress, the Departments of Justice and Education released two resources to help colleges and universities navigate the Supreme Court's decision in Students for Fair Admissions. These resources include a Dear Colleague letter and a questions and answer document. In the Q&A, OCR states that universities may continue to provide opportunities to assess how applicants' individual backgrounds, including those related to race and experiences with racial discrimination, position them to contribute to campus in unique ways. OCR also indicates that higher education institutions may articulate goals and missions tied to diversity, and continue to use strategies to remove barriers and expand opportunities for all. Some of the strategies listed by OCR include outreach, recruitment, and pathway programs, collection of demographic data, evaluation of admissions policies, and student retention strategies and programs. On August 24th, 2023, OCR issued guidance describing when recipients of federal financial assistance can develop curricula or engage in activities that promote racially inclusive school communities. In the guidance, OCR states that absent allegations of discrimination or harassment, it will generally not involve itself in complaints based on the content of academic course materials. The guidance provides numerous examples explaining that OCR may decline to open an investigation based on a complaint that news reports state a school district requires all students to read a book about racial injustice, because, on its face, the requirement applies equally to all students. OCR may also decline to open a complaint based on a teacher providing a list of articles discussing racial identity and asking students to participate in group discussions regarding their lived experiences. However, OCR may open a complaint where a college requires students to complete different assignments based on their race. The guidance also addresses instances in which it may open allegations where race related curricula create a hostile environment, and it describes how Title VI might apply to assemblies, meetings, and extracurricular activities. As a general rule, it is not permissible under Title VI to convene meetings or assemblies based on race. So OCR would likely open a complaint that alleges a school held an assembly for Black students and refused to allow white students to participate. However, it would likely decline to open an investigation where a program is designed to encourage participation from historically marginalized groups, as long as the program is open and welcoming to all students and is widely advertised as such. Before moving to the next topic, I would like to briefly note that OCR policy guidance is helpful in understanding how OCR interprets and administratively enforces the laws within its jurisdiction. However, Dear Colleague letters generally lack the force and effect of law, and I would encourage you to consult with legal counsel as issues regarding the use of race in admissions and school programming arise. Transitioning from OCR policy to a recent OCR enforcement decision in Verde Unified School District, this case provides valuable insight into OCR's approach to analyzing Title IX requirements both before and after the 2020 regulations. Additionally, it underscores the significance of OCR compliance reviews, which are initiated by OCR itself rather than individual complaints and tend to be more comprehensive, providing greater opportunity for us to reflect on our own internal processes and determine whether policies and practices can be improved. In Valverde, OCR interviewed 136 witnesses and conducted week-long on-site visits to 6 schools. Findings included 9 Title IX violations, which are listed on the slide, and 2 compliance concerns. These violations encompass procedural issues such as conflicting notices of non-discrimination and grievance procedures, and discrepancies in identifying the Title IX coordinator. OCR also concluded that the district's response to 41 incidents of sexual harassment or assault was inadequate. In some cases, despite investigations confirming inappropriate behavior by teachers or threats made by students, the district failed to implement long-term remedies or safety plans for the targeted students. A reported rape on campus did not trigger a proper investigation or Title IX determinations by the district, and the district failed to monitor an ongoing criminal investigation. When the arrested student returned to campus, the district recommended expulsion without notifying the targeted student or her parents of any Title IX determinations. Furthermore, OCR's findings revealed systemic failures within the district, specifically in terms of oversight, coordination, and responsiveness. Despite the 41 incidents, the Title IX coordinator was only informed of 5 and was not involved in investigating or resolving any of them. School administrators also incorrectly coded many incidents, hindering the district's ability to take appropriate action. These findings offer an opportunity for reflection for educational institutions of all sizes. Similar issues were identified in a recent assessment of the California state system by Coase and O'Connor. The assessment of the CSU system found ineffective engagement with system-wide Title IX and DHR compliance offices, a lack of supervision or consistency in Title IX practices, and inconsistent data management standards. Concerns also arose regarding inadequate resources, staff turnover, records management, and the need for better training and education. As schools and universities prepare for the upcoming Title IX regulations, it is crucial to keep in mind that the responsibility to provide prompt, effective responses to sexual harassment and assault complaints will not change. The Verde and the CSU assessments present opportunities to evaluate one's own internal policies. The uniform complaint procedures conflict with more specific Title IX grievance procedures. Is the Title IX coordinator correctly identified in notices, publications, and handbooks? Do employees understand when and how to report incidents to the Title IX coordinator? Is there adequate training on using the correct codes to flag potential Title IX violations? What actions do the district and the Title IX coordinator take to monitor and ensure compliance with Title IX requirements? Of course, this list is not exhaustive. However, once the Title IX final rule is adopted in the upcoming months, I hope to provide additional resources to help navigate the changes. I understand that the law is changing rapidly. It is my hope that the resources I have made available in this back to school toolkit provide a good starting place as you tackle new challenges throughout the school year. If you have questions or if you have ideas for additional presentations, feel free to reach out to me at cascadewestlaw.com. Thank you again for your time and interest in Cascade West Investigations Law. Have a wonderful school year.